Skylar Craig from the Wisconsin Institute for Law and Liberty, speaking in favor, and I believe that's probably speaking in favor of suspension. And I will check with the next speakers also, simply because some have listed against, but so we're very clear on whether for or against suspension. Skylar, go ahead.
Co-chairs, I am Skylar Croy, an attorney with the Wisconsin Institute for Law and Liberty. WILL is a nonpartisan, nonprofit law and policy center dedicated to safeguarding individual liberty by, among other things, promoting the constitutional separation of powers. I am here on WILL's behalf to explain one reason why this committee should suspend 3 emergency rules promulgated by the Wisconsin Elections Commission. WILL takes no position on the substance of the rules. However, the commission violated Wisconsin statutes and the constitutional separation of powers when it skipped permanent rulemaking procedures, instead taking advantage of a purported emergency. Because a genuine emergency does not exist, the commission acted in the absence of statutory authority, failed to comply with legislative intent, and proceeded in a manner that conflicts with state law. Additionally, the arbitrariness and capriciousness of the commission in declaring an emergency is unacceptable. This committee has the statutory power and, frankly, the duty to suspend the rules for each of these reasons. As this committee knows, enacting a law is hard. Wisconsin's founders, like this nation's, went to great lengths to prevent an excess of lawmaking, which was thought to be one of the diseases to which our governments are most liable. Wisconsin's founders went about accomplishing this goal by vesting the legislative power in a Senate and Assembly and then authorizing law to be made only by bill. To quote one Wisconsin Supreme Court justice, bicameralism and presentment are the crucible that bills must overcome to become law. Rulemaking is a suspect practice because it is essentially lawmaking that is not subject to these requirements. At a minimum, rulemaking must be exercised under procedural safeguards that mirror the difficulty of bicameralism and presentment if rules are to have even an appearance of legitimacy. Generally, administrative agencies must comply with notice, hearing, and publication requirements when promulgating a rule. Historically, however, agencies have tried to circumvent these requirements through various means, such as by issuing guidance documents. Emergency rulemaking procedures offer another shortcut, one that may be tolerable when a genuine emergency exists, but bureaucrats' ever-expanding reliance on the label emergency threatens individual liberty. Among other things, such procedures permit an administrative agency to skip holding a public hearing and comment period, which is required under permanent rulemaking procedures. The danger of emergency powers, including emergency rulemaking, became apparent during the COVID-19 outbreak. In 2020 alone, administrative agencies promulgated 48 emergency rules, 26 of which allegedly responded in some way to COVID-19. And these numbers do not account for the many times that bureaucrats just issued general orders without going through any rulemaking procedures. For example, in Wisconsin Legislature versus Palm, the Wisconsin Supreme Court struck down a so-called Safer at Home order, which was issued by an unconfirmed cabinet secretary who did not even attempt to follow rulemaking procedures. In discussing these procedures, the court noted that an emergency is a new and extraordinary circumstance, and even then, bureaucrats are constrained by law. Like the court in Palm, Wisconsin statute section 227-24-1A, in discussing emergency rulemaking, refers to the necessity, not helpfulness, of preserving public peace, health, safety, or welfare. An emergency is not whatever a bureaucrat says. The Commission, like other administrative agencies in recent years, has not complied with permanent rulemaking procedures. The Commission claims that it need not follow such procedures because the 2024 election cycle will have high voter turnout and high levels of scrutiny, but it has not explained how either threatens public peace, health, safety, or welfare. Unlike some 2020 elections, which took place during the COVID-19 outbreak, the Commission cannot point to a new and extraordinary circumstance that might, when combined with high voter turnout, create an emergency. Instead, the Commission insinuates that high voter turnout is itself an emergency because it creates administrative burdens. Notably, the Commission does not describe these burdens whatsoever. Whatever they may be, they do not threaten public peace, health, safety, or welfare. Additionally, high levels of scrutiny cannot justify rushed procedures. If anything, the Commission should proceed in a methodical and ordinary manner if it is truly worried. When the Commission waits until a few months before an election and then acts on a purported emergency basis, its conduct creates an appearance of impropriety. The Commission also says there is simply not enough time to promulgate permanent rules, which reminds me of a saying from my time in the Army. A lack of planning on your part does not create an emergency on my part. The Commission issued scope statements in September 2023. It then took until late spring 2024 for Governor Tony Evers to approve the emergency rules. The Commission waited until 6 months before the beginning of the 2024 election cycle to begin emergency rulemaking, and then took several months thereafter to finish. Even assuming 6 months is insufficient time to comply with permanent rulemaking procedures, which is questionable, the Commission could have begun such procedures in April 2023 after the spring election, which would have given the Commission plenty of time. Instead, the Commission inexplicably waited. What occurred between April and September that was new and extraordinary? Nothing. The Commission cannot manufacture an emergency by waiting until the last minute. The Commission's argument is especially troubling because Wisconsin always, or at least almost always, has multiple elections each year. The Commission's reasoning, taken to its logical endpoint, would effectively allow it to avoid permanent rulemaking procedures altogether. At bottom, this committee should not allow an administrative agency to just mouth the word emergency as a means of avoiding permanent rulemaking procedures. I urge this committee to suspend the 3 emergency rules. I look forward to answering any questions. Thank you.
Thank you for your testimony. One of the charges of the committee, even though we are out of session, the legislature, that we meet, and I consider this committee the firewall between government and we the people, because the administrative rules, as you know, have the force of law. So it's critically important what we do here. And the Legislative Audit Bureau in 2021 recommended promulgating rules, and we certainly, as you have pointed out, rightfully have a huge gap in that timeline in coming to this day where we are considering whether these should go forward or not. So I appreciate pointing that out. And the difference for those listening in, the permanent rules and the emergency rules are extremely different. Emergency rules are, as you mentioned, are rapidly moving. Permanent rules give the legislature the time to review the actions of government and to decide whether it's good or bad, to have a give and take. And we have done that, where we will go back to the agencies, whether it's natural resources, Department of Revenue, and suggest changes and work with them. We have no opportunity to do that. This either goes or it doesn't. Whereas with permanent rules, you have that extra time to provide the scrutiny, public input, and legislative review. So that is why this hearing today is extremely important to decide whether to go forward or not. And you have pointed out some of the flaws, I think, that are probably shared by committee members. Are there questions from committee members?
Yes, I have a question. Senator Royce.
Senator Royce, go ahead.
Thank you, Mr. Chairman. I think it's apt that we're talking about separation of powers when we've just had a Supreme Court ruling on this very issue, and it strikes me that what this committee is taking upon itself is essentially doing the court's job and doing the executive branch's job. That this committee is pretty problematic from a separation of powers standpoint. But I did just want to ask Ledge Counsel if it can tell us, has rulemaking, permanent rulemaking commenced for these rules? And if it's rare or somehow uncommon or untoward for there to be emergency rulemaking and permanent rulemaking running on parallel tracks.
Hi, Senator. Scott Gross here from Ledge Counsel. To answer your first question was about the permanent rulemaking. Is that right?
Yes, and just wondering, has that project process already commenced?
Yeah, so the agency has scope statements issued for permanent rules, at least subject matter wise, that line up with each of the emergency rules. They have submitted one of those rules, the same text in 2407 that's been submitted to Ledge Council. Their first draft of review was sent to our office in July, and we issued our report on that permanent rule last week. So the agency is moving along in the direction of permanent rulemaking. We haven't seen draft texts related to emergency rules 2408 or 2409 to this point. And on your second question, as far as is it common, yes, it is relatively common that agencies will be issuing emergency rules of the same subject matter as permanent rules. We see that quite regularly.
Thank you so much.
Thank you, Mr. Chair. I guess the question I have as we're looking at this is if, these things are stepping in to try and make sure that there's uniformity with instructions for absentee voting, with challenges for declarations of candidacy and challenges on nomination papers. And if we suspend these, specifically for the one on absentee voting, because that one obviously moves forward through the August primary and the November election. So I guess the question, if anyone can answer it, maybe it's Ledge Council, of what the repercussions will be. If it means then that I've seen warnings that there's potential that then there will be different instructions going out from different clerks and a lack of uniformity, especially if, and correct me if I'm wrong, Mr. Chairman, but the suggested motions only suspend. I don't think there's anything that tries to redirect. So it just literally just kind of leave it open.
I'll let Council answer that, but I do want to point out that on this particular day with the emergency rules, we can either totally suspend, that's all we can do. Mm-hmm. Permanent rule, we can work with the departments and try to have a give and take and make corrections, but we are not allowed to do that today. Ledge Council, if you want to answer.
Yeah, I think that addresses the procedural difference between the committee's powers over emergency rules versus permanent. Just for the folks listening on the phone, in addition to myself from Ledge Council, we also have Peggy Hurley and Katie Bender-Olson who staff our elections committees. They're available for additional details to your earlier question, Senator Larson.
Any other questions?
Sorry, Katie,
sorry.
there's
Katie.
swapping, they're tagging out here, tag team.
Yes, I'm just going to address the question relating to what happens regarding the emergency rule that requires the WEC uniform absentee voting instructions and what happens if the rule is suspended. The rule would prohibit clerks from distributing absentee voting instructions that are different from the ones developed by WEC unless certain criteria are met under the rule. So without the emergency rule, we currently have a process in place by which someone can file a complaint with WEC regarding an election official and a decision made by an election official alleging that it's either a violation of law or an abuse of discretion by that election official. So under the emergency rule, that current system would be the enforcement mechanism for a clerk that sent out absentee voting instructions other than ones that were the WEC standard instructions or met the other limited criteria in that emergency rule. So with a suspension of this rule, WEC couldn't enforce against a clerk for sending out absentee voting instructions that varied from their standard instructions. However, there is still a process in place for someone to challenge any instructions a clerk would issue that are contrary to state law. So that is still something that could be done by WEC. So if a clerk was issuing instructions that were just incorrect in violation of law, there is still a process in place for WEC to enforce against them.
So just, if I may, Mr. Chair.
Yep.
Just as a follow-up, so then if that scenario plays out, right, they can send out different rules, and possibly one could send out one that's in violation of the law because they're not following a clear standard that was set by WEC. If they send out one, there would have to be a complaint that's issued, or someone from WEC or someone from WEC staff or someone else would first have to notice this and then step in before any change could happen to that rule that violates, or those instructions that violate state law. There's not really a mechanism where they're going to be pre-approved by WEC before they go out.
No, and that's...
So I was just saying that there could be a potential for these to be out there for days, weeks, possibly, before anybody notices.
That's true. A complaint would have to be filed, but the same thing is true even under the emergency rule, that the enforcement mechanism would be the filing of a complaint under that existing system.
But if the emergency rule is not suspended, there would be uniform instructions that would be going out to all clerks, would there not?
There would be a statement that clerks are required, they're prohibited from sending out different instructions unless it meets pretty limited criteria. There are some circumstances in which their instructions can deviate somewhat from the WEC standard, but we wouldn't have a statement prohibiting clerks from sending out their own version of instructions.
Got it. But there's a less likelihood then, with the rule as it stands, that there would be errant instructions that violate the law, that or not trying to assign nefarious purposes, but that would go astray of what the law is. And that could happen for longer if we suspend the rules.
So in the absence of the rule, we wouldn't have an express prohibition on clerks sending out their own version of the instructions. However, it's still the case that we would have the exact same enforcement mechanism would be in place, whether or not
Sure. Got
the
it.
emergency rule is in place.
Got it. Okay, thank you.
Thank you. One of the other concerns is that, and it's necessary for us to get it right, is that if we were to let these emergency rules go through, at the present time, it creates some confusion on the 2407 emergency rule uniform instructions, because the clerks can also send out additional information. We don't know what that may or may not be. And once the rules would go into place for absentee voting, they then cannot be changed until another permanent or another rule. They would have to go through the rule process to change that administrative rule. So if these went through today and we have eventually a permanent rule and it's in law, then to change that, they would have to come back. Is that, whatever would be changed, if this goes through today, as with other administrative rules, when the department wants to change them, they would have to do another change administratively in a scope statement.
To change the text of what was
Yeah.
in the permanent rule, yes.
Right. That's my concern, that we get it right and not rush through this, because once it's there, it will take time to change it in the future. It can't just be done willy-nilly, so to speak.
So if what you're asking is once something is in the text of either the in-place emergency rule or a permanent rule, then yes, once it's there, that has the effect of law, and it would require going through the rulemaking process to make changes to that, yes.
Okay, thank you, yes. Questions? Thank you for your testimony. Oh, I'm sorry, go ahead. Ledge Council
Yes.
question?
Yes.
Go ahead.
So I just want to be clear on, the chair's question. What is the lifespan of an emergency rule? Like, how long can it be in place?
That's 150 days.
And what happens after 150 days?
Well, then the rule expires and they would have to go forward with the permanent rulemaking process.
All right, thank you.
Let Scott return.
Just to add to that a little bit, emergency rules have a lifespan of 150 days, up to an additional 120 if extended by JCRIR. When an emergency rule expires, typically what we see is either a reversion to the prior law or, as Katie mentioned, the subsequent adoption of a permanent rule related to the same subject matter. It's been relatively, I think the stakes on rulemaking tend to be relatively low, and we don't have a lot of litigation on the specifics. There is one attorney general opinion dating back to the 70s that says that multiple emergency rules may not be issued in sequence in order to maintain coverage beyond that 150-day period. And like I said, that specific issue has not been extensively litigated, but what we see in practice from most agencies is if there's a gap in timing, what we tends to see is a reversion to the prior code while the agency waits for the permanent rulemaking to finish the process and take effect.
Thank you, Mr. Chair. Just as a follow-up to that, there's an emergency rule draft that's already been prepared for 2407. How long does that process normally take?
So the permanent rules labeled Clearinghouse Rule 24-052. The permanent rulemaking process, abstractly, when we speak in generalities, we say it takes about a year. We do see cases that extend as long as 24 to 30 months for that process to be completed. The absolute quickest it can get done is, I think, 7 or 8 months total, due to the when you add up all of the different timelines and waiting periods contained in Chapter 227. We're in the legislative interim right now. That's an important time related to the timeline for permanent rulemaking, because after the last general business floor period, an agency is prohibited by statute from submitting a permanent rule. I shouldn't say that they're prohibited, but the timeline for a rule to move through the legislative review after the legislative interim requires coordination among an extensive number of legislative bodies. And in practice, what that means is most rules that are submitted after the end of the general business floor period don't see legislative review until January of the following year. This rule is, I would say, not knowing what the agency's intent is, but I would say it looks like it's on track for submission on that timeline. Review by our office is a middle step in the rulemaking process. It's followed by an agency public hearing. That case on 24-052, I believe that's scheduled for July 31st. Following that hearing, the agency will take comments it receives along with comments we provided typically on form and clarity of the rule. They'll process that into a final draft and submit it to the governor for approval before submitting it to the legislature for review.
Thank you, Chair. Mr. Roy, is it?
Correct.
Roy? Right? Okay. So you indicated in your testimony an emergency is not whatever a bureaucrat says. How can me and you know that it's not an emergency until we give permission for it to be an emergency until we find out? How can we know in advance that something is not an emergency, me and you as an ordinary people?
Representative, the statute on this is Wisconsin Statute 227-24-1A. Now, a couple of things to note about this statute. One, it refers to necessity. It does not refer to helpfulness or anything like that. It's about necessity. And it talks specifically about the necessity of preserving, quote, public peace, health, safety, or welfare. I have not heard anything so far today about peace, health, safety, or welfare. And although Will does not take a position on the substance of these rules, I would note that the idea that high voter turnout is an emergency has nothing to do with 2408 or 2409, which are about challenges to nomination papers and challenge procedures for candidacy declarations. So there does have to be some limiting principle here, and the Wisconsin Supreme Court in Palm, in discussing the very statute that I just mentioned, said that an emergency is, quote, new and also, quote, extraordinary. There's nothing that's happened here that's new and extraordinary. And I would note that the idea that a lack of uniformity is going to create an emergency is frankly bonkers, because our entire election system is decentralized. We have, 1,800 plus clerks who, unlike basically every other state in the country, often get to make their own judgment calls. In fact, we're going to have drop boxes coming up. Okay, that's going to happen. There's going to be drop boxes in this election, and there's going to be no uniformity whatsoever with respect to any of those. Is that an emergency? That might actually be an emergency. But the idea here that there's just some high voter turnout makes no sense. The other claim that they've cited, Representative, is high levels of scrutiny. How can it be that high levels of scrutiny on an election justify rushed procedures? Procedures that are not ordinary and that deny the public a chance to participate in the process.
Thank you. Thank you, Chair.
Thank you for your testimony.
Thank you.